Mr. Lewis, you have Crystal Vogan, this is sentencing. Good morning. This is Mr. Hoffpower sentencing. I didn't see you over there, Mr. Hoffpower. Good morning. Good morning. Are you Crystal Vogan? And Ms. Vogan was previously in court, entered a plea of guilty to theft of property, a state jail felony. That agreement was for a 4-year deferred probation with a $1,000 fine as well as restitution in the amount of $9,400. I've received the pre-sentence report. Have y'all all had an opportunity to review that report?
Yes.
And any additions or corrections or?
There's a lot of history we understand, but discussed it with counsel also restitution.
Speak up, I'm
I
sorry.
just want to make sure the court knows restitution, most of the main issue we're looking at, get some of that money.
Before we even get into the courtroom today, you need to understand why this case is already on thin ice. What looks like a routine sentencing hearing quickly turns into a masterclass in how not to behave in front of a judge. We're dealing with a defendant who technically secured a favorable plea deal, deferred adjudication, probation instead of prison, and a clear path to avoiding a permanent conviction. On paper, that's a legal win, but the courtroom doesn't operate on paper alone. Judges look at patterns, credibility, and accountability. And this defendant brings nearly 4 full pages of criminal history into the room with her.
I've got 1, 2, 3 and a quarter pages of criminal history. Well, there's a lot of stuff that wasn't dismissed. There were 14 felonies that weren't dismissed. At least 4 or 5 misdemeanors that weren't dismissed. I understand the restitution, and y'all know my position on that already this morning, but there's I mean, she's on probation right now in Sutton County, correct?
Yes.
Right. So do they know about this case? And what has happened over there, if anything?
I haven't done nothing. I'm still continuing on my deferred. Because I'm actually supposed to start nursing.
I can't understand you.
I'm supposed to start nursing school.
When?
I was actually supposed to start in September, but I had to wait to see.
Are you really going to be able to go to nursing
Yes,
school
ma'am.
with this type of
Yes,
criminal
ma'am.
history?
This is deferred, yes, ma'am. Because I haven't been convicted of it. I'm a CNA now.
This is the moment the entire plea agreement starts to wobble. When the judge mentions 2, 3, and a quarter pages of criminal history, that's not casual commentary. That's judicial alarm bells ringing out loud. Judges don't just count convictions. They analyze patterns. And here, the pattern isn't a one-time lapse in judgment. It's repeated involvement in theft, fraud, forgery, and other financial crimes stretching across states and years. That matters because deferred adjudication is meant for defendants who show they made a mistake, not those who demonstrate a career of similar behavior.
And it also, that was from inside the bank, and then it shows 500 from an ATM and 100 from a cash app, totaling 10,000, not 9,400. Is that correct?
And that would have been added on, that's a bank fee, I believe. I don't think that.
Well, it says 500 was withdrawn from an ATM outside the bank. Is that right? You know better than anybody.
I only went into it. I didn't have no access to the card.
Okay. So possibly the other person that was involved did that?
Only thing we knew about
That
was
was,
9,400 that was within the bank.
I wasn't aware of, Your Honor, when we did it, when I got the PSIs, when I was notified, I was in the cash wrap. But if it was a withdrawal, then that would be her responsibility joint and separately, so.
Right, it says, so
That's a request.
the contact from Do Good said that the defendant withdrew the entire loan amount of $10,000, 94 from inside the bank, 500 from an ATM, and 100 from a Cash App transaction. It doesn't matter if you did it or if the other person that you were with did it. Y'all were working together. So you're both, and what's the other status of
I
the,
don't have the other status of another person, Your Honor. This is one who has the charge. I'm not coaching on there.
This exchange about nursing school is subtle, but it's incredibly important. The judge isn't mocking the defendant. She's testing credibility. Courts regularly consider whether a defendant's stated goals align with reality, especially when those goals are used as justification for leniency. Nursing, healthcare, and medical certifications all require background checks and extensive criminal histories, especially involving fraud and theft, raise serious red flags. The judge understands that, which is why she presses the issue. And notice how the defendant responds. Not with documentation, not with accountability, but with confusion and defensiveness.
But she's responsible.
yeah. So I mean, if there was another person, and you didn't give that information, then that's, okay. Apparently the cops didn't either, so.
She went in the bank, she was the one called. Size, whether or not she had a conversation. The backside, not to my knowledge.
And hold on. So the probations in Sutton County, have they been transferred to Harris County? So you're going in person in Harris County?
Yes, ma'am.
Okay. And so it's the state's position to go forward with the agreement?
I understand the court's concern, and the state has the same. Like I said, our initial deal was to get some of the money back on our victim, however, we
So,
understand.
all right, so here's what I'm going to do, Ms. Bogan. I'm going to find that you entered your plea of guilty freely and voluntarily. Can y'all hold it down over there, please? I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. I just don't know. I just can't believe I'm the
This is one of the most dangerous moments for any defendant. When a judge openly admits uncertainty. When you hear a judge say, "I just can't believe I'm even considering this." That's not empathy, that's doubt. Judges rarely verbalize internal conflict unless something feels fundamentally wrong. And here, the issue isn't whether probation is appropriate. It's what kind of probation. Deferred adjudication is essentially a second chance with an eraser attached. Completed successfully, and a conviction can disappear. But with 14 prior felonies of similar nature, the judge is asking herself whether granting that eraser undermines justice itself.
I mean, it has to be straight probation, and I realize that that's going to potentially have some issues, but I can't with 14 prior felony offenses, same type of thing, so.
I don't.
You do,
No, I don't. No, I don't.
okay? How many do you think you have?
I have 3 here and one back home.
Okay, you have lots of them that were at the same time for different offenses.
And I was never convicted, never charged.
Yeah, you did probations for them. Forgery of a financial instrument. Don't talk over me. March 3rd, 2008, Harris County, 180 days in jail, so that one was reduced. March of 2014, forging identification cards in Cuyahoga County, Ohio, 1 year probation. Same charge, same probation, so that's 2 in Ohio. March of 2014, aggravated theft in Ohio, another probation, the same date, but still another charge. March of 2014, attempted drug possession, pled guilty, 1 year probation. March of 2014, same thing in Ohio, possessing criminal tools, probation, all of that. It was at the same time, but still different cases. November of 2014, forgery, 2 cases, got probations in those. I'm going to run out of fingers. March, another one, a theft, aggravated theft in Ohio in 2014. Then we go to Sutton County, Texas, and you have 5 continuous smuggling of persons for pecuniary benefit.
When the judge lists out the defendant's criminal history, this is no longer a debate. It's a record. Each charge is being placed on the scale, one by one, and the weight is crushing. What makes this especially damaging is that many of these offenses are nearly identical in nature. Forgery, theft, financial manipulation. Courts treat repetition as proof of intent, not coincidence. And then comes the Sutton County cases. 5 counts involving smuggling for pecuniary benefit, regardless of how the defendant tries to reframe it. Probation on multiple human smuggling charges fundamentally changes how a judge views risk. This is a turning point. When a defendant interrupts, challenges a judge's understanding, and attempts to correct the court, the plea agreement effectively dies in real time. Judges do not tolerate being talked over, not because of ego, but because courtroom order is non-negotiable. When a defendant demonstrates an inability to follow instructions during a hearing, it signals how they might behave on probation. The judge doesn't need to speculate. The evidence is happening live. Rejecting the plea agreement is a direct consequence of that behavior. And when the judge resets the case, that's not mercy. That's a warning. Unfortunately, the defendant doesn't take it.
Okay.
That's not correct.
No. Okay.
So how many cases are you on probation for in Sutton County?
It all ran together.
I understand it all.
It's one.
It doesn't run, but that's not how it works.
Yes, ma'am. Yes, ma'am.
When it runs together, it just means you're serving it at this. I'm rejecting the plea agreement. I'm resetting your case for 3 weeks. We'll see you back in 3 weeks. Y'all can talk about it then. You're at, ma'am,
What?
this is not going to help.
It don't matter. My life's going on.
Well, looks like you did that, not me. I'll see you in 3 weeks. Come on, hold on, get her, don't let her go. Come back. Everybody heard it.
You're bullshit.
Come back.
Sure, lawyer.
I told my lawyer he was bullshit. I didn't say that.
You don't talk like that to anybody in this case because he didn't do this either, you did.
He got me the plea.
He did get you he did a great job. I'm going to find at this time that your bond is not sufficient because of your attitude and because of your criminal, because of your,
I gotta go to work. So I'm gonna lose my job and everything too.
Well, maybe you shouldn't cuss at your lawyer. Maybe you shouldn't have this attitude here in the courtroom. I'm going to raise your bond. What's the bond currently set at? Don't cry now after saying it's bullshit to him and acting like this in here. Stop. No, you're going to make it worse. You're just going to make it worse. You should, when I told you a minute ago to stop, you should have stopped when I told you to. All right, I'm going to set your bond at $25,000. Go back with the bailiff.
Who's on me like that?
Raising bond is one of the clearest signals a judge can send. Your behavior has made you a risk. This isn't punishment for emotions. It's a response to defiance, instability, and lack of control. Crying now doesn't undo the earlier conduct. Judges expect defendants to regulate themselves, especially when their freedom is on the line. What's tragic here is how preventable this outcome was. Silence would have saved her. Respect would have saved her. Instead, her own attitude transformed the sentencing hearing into an immediate financial and legal setback, one that could cost her employment, housing, and credibility moving forward. This case is a textbook example of how courtroom behavior can override even the most generous plea agreement. The judge didn't deny probation. She denied erasure. And given the defendant's extensive criminal history, repeated financial crimes, and courtroom conduct, that decision aligns squarely with judicial responsibility. The law gives second chances, not unlimited ones. And as we transition to the next case, the lesson is clear. Judges don't just listen to what you say. They watch how you say it, when you say it, and whether you know when to stop.